Hello, I'm Bob Lang, and I'm a staff attorney with the ABA Commission on Immigration. And I'm going to take care of a few housekeeping things, and then we're going to start our webinar on legal access program. So I want to thank you or welcome you to the webinar that's sponsored by the ABA section of Civil Rights and Social Justice and the ABA Commission on Immigration. Civil rights and social justice has a goal to rapidly respond to government action that may impact civil rights and civil liberties by offering free webinars, commentary, podcasts, social media posts, and other information from subject matter experts. I encourage you to check the section website at www.americanbar.org/CRSJ. Also check their Facebook page and their Twitter handle at ABA_CRSJ for more news and information and replays of their great programming. And if you like the work, you're invited to become a member of the section and collaborate with them on projects you want to develop and offer to their members and to the general public. I work for the Commission on Immigration here at the ABA, which directs the ABA's efforts to ensure fair treatment and full due process rights for immigrants and refugees within the United States. I invite you to visit our website by searching for American Bar Association Commission on Immigration, where you'll find video of our past programs, publications, information on our current projects, and information about our offsite projects in Houston and Harlingen, Texas, and San Diego, California. During today's program, if you're so inclined, you can pose any questions for our panelists by finding the question box on the right-hand side panel and typing in your questions. There will be a time at the end of the presentation for our panelists to answer the questions. Also on that panel is a handouts drop-down where you can access materials from the ABA and ICE, and we'll be sharing a recording of this program with the handouts to everyone who has registered so they can share it widely with their networks. Please feel free to leave us feedback and ask us any questions to follow up. So we're pleased to present this program, Enhancing Detained Individuals' Access to Legal Resources and Representation While in ICE Custody. I'll be doing a brief introduction to the program about the origin of the National Detention Standards and the different ways in which the ABA has been involved in working to improve implementation of the standards since 1999. You'll hear from our two panelists, Julie Plavsic, Legal Access Coordinator, and Eric Benson, Policy Analyst at the U.S. Immigration and Customs Enforcement and Removal Operations, ICE EOIR, ERO. And they're here in Washington, D.C., and they're going to discuss legal access for detainees and how you can communicate with their office to correct any legal access issues you encounter in your day-to-day work. Before I start, I want to say a few words about why ABA is presenting this program with ICE. I've been a social justice lawyer for 41 years, and my career sometimes seemed like an unending battle to overcome barriers to justice which have been placed in my client's path. And those of us who work in immigration have all had our ups and downs with ICE, and sometimes it seems like it's an us versus them situation. But I found that there's always some good people that are trying to help us, and Julie and her team are sincerely dedicated to seeing that the rights of detainees are respected. I'm in contact with their office several times a week regarding concerns that are raised in calls I receive from detainees. And I can say, while the detainees don't always get what they're asking for, Julie's office always quickly investigates and promptly sends me an honest response to my inquiry. So I invite you to use the information in this webinar regarding legal access and to follow through with Julie and her team when you encounter issues in your work. So what is the origin of the National Detention Standards that we're going to be talking about, and how did the ABA get involved in? Some of this is ancient history. In 1982, the United States District Court for the Central District of California decided the case of Orantes Hernandez v. Smith. And in that case, the court held that the INS which is the predecessor of ICE, had been routinely violating the rights of Salvadoran refugees who had fled the civil war in their country. The court ruled that Salvadorans had been routinely denied information regarding their right to be represented by an attorney, to have a deportation hearing, to apply for political asylum, or to request voluntary departure. In addition, the court found restrictions on their access to justice, including restrictive visitation hours for counsel, denial of access to legal material and to telephones, and arbitrary placement in solitary confinement without any disciplinary process. To remedy these violations, the court ordered access to justice protections were applicable to Salvadoran detainees, no matter where they were detained in the United States. Now, this created confusion in facilities that were holding both Salvadoran and non-Salvadoran detainees. So to standardize the protections ordered by the court, the Clinton administration in 1999 ordered the Department of Justice under Attorney General Janet Reno to draft standards which were meant to reflect the fact that INS detainees were in administrative detention, which was not meant to be punitive, but rather to ensure they appeared for their immigration hearings. As part of developing those standards, the Department of Justice in turn solicited the assistance of various non-governmental organizations that worked with detainees to draft standards in areas where they had expertise. The ABA was asked for input on the access to justice standards. These included access to visitation, telephones, mail, law library, and group rights legal presentations. Other NGOs assisted with standards addressing things like religion, medical care, recreation, etc. In fact, my first major project at the ABA in DC was drafting those access to justice standards. So why does the ABA continue to be so interested in the detention standards? In the process of drafting the standards, there were two important ABA projects that came out of it. One is the detainee hotline, which allows detainees locked up in any of the detention facilities in the United States to contact our office. And the original purpose of that, major purpose, was for them to report violations of the detention standards, which we could pass on to ICE or INS headquarters at that time, and also to provide legal orientation to detainees and assist them in seeking pro bono representation. And that's the project that I supervise here. The other ABA project that came out of that was the Detention Standards Implementation Initiative, DSII, and this allowed delegations of lawyers to go into detention facilities, talk to staff, take a tour, talk to detainees, and then write a report on their findings about how well the standards are being implemented. At that time, the ABA was the only organization in the US that was allowed to enter detention facilities. Now, as you know, under the stakeholders policy, many groups can go in, but the ABA continues to do those types of visits. And the goal of all these projects is to bring violations of the detention standards to the attention of ICE. In the meeting materials included in this webinar, there's additional information about the history of the National Detention Standards, different types of detention facilities, and you can review that material after the program. And I encourage you to contact me with any questions or concerns you have about access to justice or other issues regarding detention. So I'm now going to turn it over to Julie and Eric to discuss enhancing detained individuals' access to legal resources and representation while in ICE custody.
Thank you so much, Bob. As Bob told you, my name is Julie Plavsic, and I am the Legal Access Coordinator at ICE ERO. And I also work on the parental interest child welfare portfolio there. Just a quick overview of what we're going to cover today. I'm going to tell you a little bit about our division, the Custody Programs Division, where we're situated within enforcement and removal operations at ICE. I'm going to give a brief overview of the legal access program and what our current projects are targeted towards, a review, as Bob said, of the detention standards. We'll delve into the legal orientation program a little bit more and talk about additional resources such as the ABA Know Your Rights video. And we'll be passing along our contact information as well. And these two slides that are going to come up next are just to give you folks who might not be familiar with where ICE is located across the country. This is just the map of the field offices. There are 24 field offices, and the little yellow stars denote where the field offices are located. And they're called, each field office encompasses an area of responsibility. And then this is a map of the detention facilities. As you can see, there are a lot of them. There are larger detention facilities, dedicated facilities, and also the smaller county jails and so forth are included in this map. So the division that Eric and I work in is the Custody Programs Division. And here's a little overview of where we sit. We are part of the Department of Homeland Security, Immigration and Customs Enforcement, and we are under ICE, the enforcement and removal operations, the component that deals with all things related to detention. And we are a component within ERO, Custody Management Division, and then under Custody Management Division is our shop, the Custody Programs Division. And just to give you a little bit of information about our division, we are a small division, and we work on policy, developing policy and implementing policy and programs. And we also monitor the implementation of those policies and programs. And there are various areas we work in addition to what I told you, the parental interest and legal access portfolios. We deal with the care and custody of LGBTI detainees and transgender detainees in a specific memo for transgender detainees. We used to have the family case management program, which ended in 2017. The Prison Rape Elimination Act implementation, the Detention Reporting Information Line, which Bob mentioned, and several more. We do segregation monitoring, religious services, custody resource program, which uses the expertise of social workers to help with things such as mental illness and trauma in custody, and disability accommodation. So a little bit about our legal access program. This program strives to facilitate meaningful access to legal resources and representation for individuals detained in ICE custody. And we are a small team, and we realize that the need is immense, and the detention network is vast. And we are taking one project at a time, trying to develop some processes that can help once a person is detained and finds problems getting access to their legal representatives or to resources. So basically, we're focused on increasing the availability of and access to self-help legal resources. As many of you will know, very small percentage of ICE detainees are represented by counsel. It's vitally important that people have access to resources so they can represent themselves pro se. Facilitating expanded availability of and access to legal rights and responsibilities presentations, also known as Know Your Rights presentations, that are conducted by pro bono legal service providers, and also the legal orientation program, which is administered by legal service providers funded through the Executive Office for Immigration Review, Office of Legal Access Programs. We try to identify and implement best practices in facilitating detainees' access to counsel, and we also ensure proper routing and resolution of questions and concerns related to legal access from various stakeholders. And we do this primarily through a dedicated email inbox. I'm gonna let Eric talk a bit on the next slide because he is the one who monitors that mailbox daily.
Thank you, Julie. Just by way of an introduction, my name is Eric Benson. I'm a policy analyst at ICE ERO Custody Programs Division, and I support the agency's legal access initiative. So part of what I'm doing at ICE is finding ways to connect ICE detainees with legal resources, legal information, and attorneys. So one of the ways that we are ensuring the proper routing and resolution of legal access questions is through a publicly available email inbox. That's detention, see it on the screen there, .legalaccess@ice.dhs.gov, and we'll repeat that at the end. And this is a place for attorneys, family members, and other stakeholders to submit questions that relate to detainees' access to legal information, legal resources, and attorneys. So for example, sometimes attorneys will email us at that address and ask how they can get in touch with their client or with specific ICE personnel. And Julie and I will be monitoring that inbox, and we will try to find a way to help resolve any issues that are raised there. For detainees, they have the detention reporting and information line that's commonly referred to as the drill. And this is a place where they can raise their concerns, and among those, there may be legal access concerns. For example, access to the law library at a particular detention facility might be something that a detainee might raise over the drill. So we will also see those issues in that they're routed to that mailbox. So we will address those issues as well. Hand it back to you, Julie.
Could I add one thing, Eric? Is for the people who are working in detention centers, the drill line has a free calling number. It's 9116#. So you can pass that on to detainees. Okay.
Thank you, Bob. I think that might be on our fact sheet
Okay.
as well. So the materials you were provided, the drill. Actually, we have the 1888 line, which is the public number, but yes. So yeah, we can change that and we can send it out certainly after this. If you want to write it down, that 9116 is the speed dial. Thanks for pointing that out.
Surely, go ahead.
Yes, and I'm very embarrassed as I look up and see that we misspelled our email address. The inbox address is missing a C. But it is the correct address is on the fact sheet that you have. And just to give you kind of an idea of some of the things we're working on right now, we have a project to enhance the use of VTC or video teleconferencing technology for confidential attorney-client meetings. Right now, we have this available at 7 facilities, and we have a plan to expand that. Don't quote me, but at least to 3 more within the next fiscal year. Hopefully more than that as more facilities come online and the technology issues are kind of resolved. I think it'll be easier and easier to get that into more detention facilities. And this is mainly aimed at particularly remote facilities around the country. so that attorneys don't have to drive for hours and hours every time they need to meet with their clients. And it in no way does replace in-person meetings. It's not meant to replace or curtail. It is meant to be in addition to in-person visitation. We're also working on increasing accessibility to the ICE Pro Bono platform in all detention facilities, as Bob pointed out, that the ABA and the drill both have speed dial numbers on our platform. It's free for detainees. There's instructions on how to use it. An example of a stakeholder inquiry we might get is that my client is trying to reach me on the Pro Bono platform and is unable to get through. And usually it can be a little tricky. It can have some detailed instructions on how to use it. And so we will then ask somebody on site at the facility there to assist the detainee in accessing that Pro Bono platform. It's got a number of free legal service providers, pro bono legal service providers are on it, but also consulates, governmental and non-governmental organizations. Another big project we have is improving law library resources. We're trying to include more self-help materials in our law libraries in both hard copy and we have an electronic database as well with resources. And if you all have any suggestions on good self-help materials, especially in secondary languages out there, we have some in Spanish, but we don't have many other languages. Please let us know. We're happy to include secondary resources in 4 languages and also in English. If you could just send it to us and we can get it in there as soon as we get it kind of cleared by our attorneys to include. We're also trying to provide more guidance to the law librarians so they can assist detainees with the electronic resources, which can be a little tricky also to access. So back to the detention standards. I think I'll kind of skip over these slides because Bob did go over a bit of the evolution, but basically there are 3 versions: the 2000, the 2008, and the 2011. And there's also the ICE family residential standards, which apply only to the family residential centers. There are 3 of those, but they are not applicable outside of those family residential centers. So we have the National Detention Standards from 2000, the ICE Performance-Based National Detention Standards in 2008 that were updated in 2011. And we did have an update in 2016 that is available online, but the updated version of 2016 is still called the 2011 standards for reasons I won't go into. But you can access all of these standards online. I can provide a link. You can also Google detention standards. They'll come right up, and there's links to all of them. And so it varies where which facility depends on the contract, who will be under what version. But PBNDS 2011 is kind of the most, the best and the most detailed for legal access issues. So all of the versions of ICE detention standards, even though we have these different versions, they really are very, very similar when talking about legal access issues. So the relevant standards, the first one includes law libraries and legal material. And this basically deals with that detainees have access to the court's counsel and materials, a properly equipped law library, legal materials and equipment. They should have, it states that they should have meaningful access, which is interpreted as no less than 5 hours per week. PBNDS 2011 calls out where possible that access should be no less than 15 hours per week. And then all detainees, regardless of housing or classification, should be given access to the law library. They also include some other information on that the detainee should have a means of saving any legal work they do in the library. They should be given sufficient materials, paper, pens, etc. They should be able to make photocopies for free of legal material. That facility staff should provide assistance to detainees in accessing legal materials, and this is one we get a lot of inquiries on, and we're trying to do better in that regard, and getting our law library and other personnel trained up on assisting in that regard. The facility should permit the detainees to retain all their personal legal material upon admittance, and the detainees should be notified of the facility rules on law libraries and legal materials through the detainee handbook. And we also encourage facilities to prominently post law library hours and instructions on how to request time in the libraries. The next detention standard is the legal telephone access. This is part of a larger standard covering telephone access in general. And it points out that telephone access procedures should foster legal access and communication with attorneys. Detainees should be able to communicate effectively and confidentially with their attorneys. That the facility may not restrict either the number of calls or the duration of calls between attorneys and their clients. The facility shall have a written policy on the monitoring of detainee telephone calls, and including the procedure for obtaining an unmonitored or privileged call. And if this is not requested, then all calls are recorded and monitored. But once it's coded as a legal call, then it will not be. The facility must prominently post the current Executive Office for Immigration Review list of free local legal service providers and provide free phone calls to those listed on the EOIR list for the purpose of obtaining representation. It says for the purpose of obtaining representation, but really they could call their attorneys from this free call platform at any time. The next standard governs visitation, and the legal visitation piece we pulled out here. It talks about visits between legal representatives and detainees, and that they should be confidential and not subject to auditory supervision, meaning they could have line of sight supervision, but they should be seen but not overheard. That we should have private consultation rooms available for attorney-client meetings, that documents and other written materials during a visit should be able to be exchanged. They can inspect the materials, but should not read them. Detainees are entitled to retain legal material for personal use. And again, you'll see this throughout the standards. Detainees in administrative or disciplinary segregation shall be allowed legal visitation on par with the general population. And the facility must provide, upon request, legal visitation policy. That includes hours, procedures, and standards. And then we have a specific standard on legal rights group presentations that ensures access to information presented by ICE authorized persons and organizations for the purpose of informing detainees of immigration law and procedures. This includes both pro bono legal rights group presentations as well as the legal orientation program, LLPs, which we discussed before. The So I think I mentioned before, EOIR carries out this program through legal service providers in consultation with ICE. And all facilities are required to cooperate fully with all authorized persons seeking to make legal group presentations. And I rely on that one a lot when I'm contacted by a group who is having any kind of access issues. This is the standard we can point to encourage the facility to allow the groups to make to gain access and make presentations. And now I will spend a little bit more time on the legal orientation program. In my opinion, this is probably the most important thing that detainees have access to within detention. It's likely going to be the only time they're going to meet in person with attorneys or anyone who can give them really detailed information on immigration law and what the process entails and what to expect. So the LLP, as we've discussed, is administered through the Executive Office for Immigration Review, Office of Legal Access Programs. The goals of the LLP is to include improve access to legal information, improve judicial efficiency. LLP has been shown to have a positive effect on the immigration court process. Detained individuals making informed decisions are more likely to obtain representation, and that means their case is perceived faster, with fewer continuances and less time in detention. And the LLP is typically comprised of 4 components, and I'll just say that the pro bono legal presentations done by pro bono group that aren't under LLP pretty much all follow, at least the ones that I've seen, all follow more or less the same structure. There's an interactive group presentation that provides general overview of immigration removal proceedings, forms of relief, and it is open to general questions. And after the group orientation, the providers will do individual orientations where non-represented individuals can discuss their case with experienced attorneys. They oftentimes will conduct self-help workshops based on the needs of the particular population. And that's those with potential relief who want more detailed information on what they need to do to represent themselves can get very detailed help in one of these workshops. And the LLP providers also refer, they are not representing the detainees directly, but they will refer them to pro bono legal service providers, generally those listed on that EOIR list that we discussed earlier. And just to caveat that, it's, as most of you, or those of you who, I'm not sure if we have many participants with intimate knowledge of the immigration process. I think we have quite a few, but it is extremely hard to get, for a detainee to get representation from one of these groups. The need is very, very high, and the capacity of these organizations not particularly high. So that even a very deserving person with a good meritorious case may not be able to get access to a pro bono legal service provider. So there is a memo, an internal memo that is an ICE memo issued by ERO that expresses support for the LLP. It encourages field offices to establish consistent times and adequate space for LLP group orientations. It encourages the designation of a point of contact to help facilitate the relationship between the LLP and the facility and ICE. encourages field offices to help identifying detainees eligible to attend the presentations, to allow detainees to keep their legal documents with them and bring them to the LLP presentation, and also to ensure that the LLP materials are available in the law library. And right now, the LLP materials are in English and Spanish, and we have both versions in all law libraries. And this is just a chart. We did a survey because we know how many legal orientation programs are in ICE facilities right now. I believe it's 37 facilities across the country have LOPs, but we didn't know how many facilities outside of those that have LOP had these pro bono legal rights presentations. So we surveyed facilities over, I believe we did over 50 average daily population, and found out that we actually, at 29% of the facilities, this probably isn't an exact number, it changes depending on capacity and could change from day to day, but as of the time we did this research, 29% were getting the pro bono legal groups or presentations or Know Your Rights presentations, and 71% were receiving the LLP program. And that added up to 80% of detainees who have access. That doesn't necessarily mean 80% get to orientation, but this is just roughly 80% that have access to some sort of legal programming. And a couple of other resources we wanted to point out. The ABA did a Know Your Rights video. It's quite old now, I believe. Yes, it was last updated in 2012. And it's in English and Spanish. It is in other languages as well. I believe Creole, French. I may be missing one or two, but we have that available in most facilities. They commonly will show that video at the intake, in the intake room. Many times it's on a loop in the housing units. And we're currently trying to make the video available in the law libraries for individual viewing. It's a very good video, but also can be quite overwhelming for someone sitting and trying to watch and digest it, especially in the environment where it may be noisy and there may be a lot going on, or they just might not be in the right frame of mind to see it at that time. And if we can get it into the law libraries with headphones, and people can stop and start it and go to their the most relevant section for what they want to learn more about, and I think it could be much more useful. And it basically just has an overview of the court system, similar to the LLP, but much more detailed on the court system and what to expect in court. And we've just pulled together some of the law library best practices. We try to encourage, at a minimum, these things listed here. They are requirements for the most part, so they really should be doing these things. But I told you about the 5 hours of access, but we do try to encourage more than that in the public posting of library hours, and the ability to save the legal research, as I mentioned before. And we have the secondary self-help materials, but we also have the LexisNexis is our vendor at this time. We have a whole lot of legal resources that are very they're basically for lawyers, immigration lawyers, more than they are for detainees, but they're available there. They sometimes do use these very, very detailed legal resources from LexisNexis. We are right now hoping to improve the interface of that system and put more and more self-help materials on there to make that a little more user-friendly. And also the provision of special materials for detainees with disabilities, such as blind and hard of hearing detainees. And that is the end of the presentation. Our contact information. Oh, I have the federal contact sheet info here. These are just various organizations that and access points. There's information on USCIS, EOIR, and we have a joint intake centralized complaint center for DHS that we also get a lot of complaints and inquiries through. The Office for Civil Rights and Civil Liberties, and the Office of Refugee Resettlement. And here's a slide with we have the email address, again, spelled correctly this time, detention.legalaccess@ice.dhs.gov. And right now there are 3 of us. I'm the Legal Access Coordinator, and Christopher Cady and Eric Benson are policy advisors. And now we have a good bit of time for questions, so I will turn it back over to Bob in the audience.
Okay, so yeah, we do have a number of questions, and I'm going to answer the first one myself. There was some concern about how to Google the various types of standards, because there's 4 different groups, but it's actually very simple. If you Google ICE 2000 National Detention Standards, that will give you the page to open that. When you open that page, on the right-hand column, it will also say 2008 PBNDS, 2011 PBNDS, and family residential. So once you find one set, then you found them all. And I look at them every day. One of the questions was, or we had several questions about whether or not the PowerPoint was going to be made available.
Oh, yes. Did you want me to answer that?
Sure.
I'm sorry, an incoming call coming on in this office I'm in, so I'm just going to take that off of the phone. Yeah, so unfortunately we are not allowed to share the PowerPoint, but the fact sheet really summarizes a lot of the key points that are in the PowerPoint, including the relevant detention standards, how to contact us. It's just that we, for formal presentation, we would have to go through so many channels to get this officially cleared. So we kind of make a shortcut by having the fact sheet available for distribution. And certainly any questions, you can contact us and we're happy to send you more information.
Okay, thank you. Are you able to tell us which 3 facilities are going to get VTC, the video?
We are working on that. So we have a plan where we kind of went through and looked at the highest average daily population, the remote nature, how far from a metropolitan center, and we came up with sort of a priorities list. So we're kind of working through that, but we don't have any concrete. We can't confirm yet which facilities will come online next. I can tell you the ones we are currently using VTC in. They are Stewart and Irwin detention centers. They're both in Georgia. The Folkston Detention Center, which is actually in Florida, but under the Atlanta AOR. There's Cibola in New Mexico, and Pine Prairie and Gina LaSalle facilities, and the New Orleans area of responsibility also are, those are our latest, those two are the latest additions.
Okay, and a question from an advocate in Pearsall, Texas. How do we as a pro bono legal services provider get on the pro bono platform at Pearsall?
So my first question would be, I hope I can pose a question back, or I can just say generally that if you are on the EOIR pro bono list, then that is very easy. In fact, you should already be on there. If you're not on that list, and I know a lot of organizations choose not to be because they don't have the capacity to be on the widely distributed list, you can contact us and we can request that that our phone service provider adds your organization to that list. If you can provide us some information on some indication that you are in fact providing pro bono services there, we can request that our phone service provider, Talton is the name of the country, they provide this service as it's for free to ICE basically, and so we have to ask them before they add someone who's not on the EOIR list, but they generally are amenable to doing that. So you can send it to our mailbox or to any of our email addresses, and we can try to facilitate that for you.
Thank you. Next question. Does the ERO Legal Access Program cover detainees who were moved into U.S. Marshals custody only because they are repeat offenders as undocumented people?
Yes, that is that's a rather difficult one. Our standards should apply to ICE detainees wherever they are detained without question. We can run those. It's not as much of a well-oiled process when the BOP is involved. Our communication channels aren't as well established, and we work through the field office. But if there are questions whether detainees are being, or if there are violations of basic access to counsel and basic questions that they should be entitled to, we can run that down on an individual basis. You can send us what the issue is, and we can try to get that to the right person to resolve it.
Okay, thank you. A question about which standards apply, and the question is, when contracts are redone, why are the newer standards not required? Why are so many facilities allowed to remain grandfathered under older standards?
That is a good question. I might have to get back to, if you want to send that question to us, I can try to get you a better answer than I'm prepared to give right now. I'm not as much, I'm not as, I guess I just don't know the answer, so I could try to run it down for you is the short answer.
Okay, thanks. I will forward that to you.
Okay, thanks.
Okay, the next question is from Florida. How are literacy barriers addressed? Are materials available in different formats? I know that in Florida, literacy levels for immigrants are huge barriers. So even if print materials are available via a library, that might not grant access to information.
Yes, this is quite a difficult one as well. We have a language access coordinator at ICE that I would, if you have specifics to this question, that I could forward specific questions to. I know that it's a big problem, and I don't really have it. We try to one-on-one forward those concerns onto the language access coordinator who this is a big part of her work. And we can right? We just don't have a general way to address this. I mean, it's very difficult for even for Indigenous language speakers also, and I'm afraid there's just not a good answer. But if you can forward specific concerns about an individual who's not able to access materials, we can work on those case by case. We're looking at ways to improve access for illiterate and low literacy, but there's just, I'm afraid, not a really positive, good answer I can give right now on that front.
Okay, thank you. Next question is, obviously funding for LLP programs is limited, but there are a number of us who do Know Your Rights, KYRs, and provide pro bono representation to detainees without being an official LLP. Is there any way to gain access to the is there any way to gain the access benefits of being an LLP without receiving the funding? Let's see, example, having access to rosters and dockets for the detainees.
So this question we get a lot, and it's going to be very specific as to the field office you're working with. What is covered in the standards is that it's not very prescriptive. It says that the groups that are approved by ICE to provide presentations should have access to the facilities. It's generally not on the same par as the LLP, simply for the fact that the LLP is seen as a government-funded program. There's a little more access to information for them as being an official government-funded program. So what has happened as a result is that different groups providing the pro bono presentations have different levels of access. We do have some kind of baseline best practices that we suggest to the field office, and I guess I should make clear, or I should have made clear from the start, that we really advise the field offices on a lot of these matters, and a lot of these things are going to be within their discretion. So we can reach out and say, we've developed these best practices that groups should have access to certain level of information. Would you consider providing more, or what specifically they're asking for? And again, we would need to do that sort of on a case by case basis, because it's going to vary so much depending on the AOR and the area of responsibility in that particular field office.
Thank you. Next question. Do the legal documents that detainees are allowed to retain include a copy of their NTA, the notice to appear?
I believe that it should always be something that they're able to retain. Again, it's a very specific question that I can't say all across the board yes, but that should be something I believe they should be able to retain.
I agree with that. That seems to be the practice. So, yeah. But I think that's a perfect example of someone's not allowed to retain it, and for the type of thing that they might contact you about to get some clarification.
Exactly. Yeah.
And then there's a request to show the slide with all the contact information again. That's also a handout that should be showing on the right-hand side of the screen for viewers.
I'm assuming if it's the contact information for us or for the federal contact info, we can make both of those available. We'll make sure that those are available to you after the presentation. It's probably not there right now.
Correct. And someone pointed out that Folkestone is Georgia, but there's some confusion because Folkestone is in Georgia, but it's covered by the Miami field office, as I understand it.
Is that your question, Bob? Or that's
No, I'm just, there was a question here where somebody wanted to point that out.
It was part of the Miami field. I probably misspoke to that. It was part of the Miami field office, but it's my understanding that it's now under the Atlanta AOR. It has changed. It's kind of on the edge, so it has changed over to the Atlanta AOR.
So let's see. What is your position on the situation where parole seekers were denied access to contacting ICE to follow up about their parole and were put into punitive indefinite segregation as retaliation for peacefully protesting the denial of access to ICE by the private contractors running the facility?
I am not familiar with this particular situation. I would need more information, and again, trying not to be non-responsive, but if you could send the information, the question to the box, and I can do a little more digging into the context, I'd be happy to try and answer it.
Yeah, so if I could just point out, like I said that I contact her office several times a week, and a lot of times this is similar to the kind of question that I've asked you. And the benefit for the people on our side that are working with the detainees is that in my experience, you have done the investigation, you've contacted like the field office or the facility or something to clarify facts. And in my experience, when a facility is doing something that is over the line, or even if they have a legitimate or a reason why they say it's legitimate, they will often stop doing it once they know that your office has taken an interest in just following up with it. So that, I think that's one of the big values for us, is so often people in the field are frustrated because maybe they're not getting information from the field office and they think that they're stonewalled and that's the end of the thing. But your office offers an opportunity to, try another door to get more information on that.
That's exactly right. We've developed legal access points of contact in most of the field offices now, and we have people that we forward these requests to that are generally, they're either on the assistant field office director level or on the supervisory detention deportation officer level. And sometimes it's a matter where an attorney is dealing with a caseworker or the deportation officer of the detainee, and they're not getting anywhere, they're not getting a response. And certainly once somebody who's higher up sort of says, we got this, what they do is we just send it to them and say, a lot of times it's, we've got this call on the drill that this is happening, can you look into it? And then they would send it on to their person that's on site at the facility, and so on. And it's sort of shines a light on things, and sometimes people just, they're doing something that they just, sometimes they don't even know they're supposed to be doing something different. And so that really helps the communication. It helps, just to shine a light on the issue, can get it moving.
Correct. So the next question says, is there an opportunity for a JD Law School graduate waiting to take the February bar to start helping now? If so, what are the avenues? And I have a thought on that, one of which is that is to contact NGOs that are working close to where you are to see what assistance you could be to them. And if you don't know what those groups are, you could contact me. You can send me an email. My email is robert.lang, L-A-N-G, at americanbar.org, and American Bar is one word. So robert.lang at americanbar.org. you can write to me and I can give you a list of the groups that are working in your area, and you could be quite an asset to them, I think. I don't know, Julie, Eric, do you have any other thoughts on that?
Yeah, yes, I think you're absolutely right. I would just add to that. I know that many folks don't see themselves ever working for ICE, but we do have internships and entry-level jobs for new graduates. Eric is, in fact, one of our recent recruits who, I hope you don't mind me saying, Eric, maybe you could talk about just real quickly your law school experience and and how you feel now working in the agency.
Yeah. So first of all, if you have any questions about internships, just send me an email and I can get that to the right person, or I'll respond directly to you. I recently graduated from law school in May, and before I took the bar exam in July, one way that I was getting involved was I was part of a pro bono legal project down in Texas, where I was at a detention facility for a number of weeks doing legal intakes for asylum seekers. So if you could find a project of that nature, that might be something that you might be interested in.
Yeah, my advice on that is to go where you're needed and where you can do the most good. And a lot of times that's right now that a lot of the places along the border are really needing assistance. And so you can contact those. So here is, and again, this is a question that I think would be the kind of thing that I would send to you. I don't know if there would be an answer to it, but it says, I recently lost my cell phone privileges because I was using Google Translate to communicate with clients from all sorts of linguistic backgrounds. The decision came down from the warden. What would your advice be as to my ability to use phone apps to communicate with clients? How do I remedy this problem?
So undoubtedly, you should have the ability to communicate with a client through an interpreter if you need to. And I realize this is very specific to cell phone apps. This is a general policy that we should accommodate interpreters. So whether the facility allows phones at all, whether they allow the translation apps, or how that's handled is going to be very facility specific. But if you can send me the issue in the facility, maybe there's an alternative to the app based or the Google Translate avenue, and I can loop in the language access coordinator, and we can try to assist on that with the facility and the field office.
Okay, and again, there's a question about the speaker contacts, and this, I believe this is included in the materials. Julie?
Our contact information?
Yeah.
Is that the question?
Correct.
I'm going to make that available after. I'll pull these two slides with the contact information and make that information available.
Okay, and then there was a question of how can an advocate determine what detention standards are in effect in the detention facility where they're working?
I believe you can just ask. You can certainly ask us. We can tell you. I don't believe it's publicly listed anywhere, but if you ask the field office or the facility, they should be able to tell you, and we can certainly tell you.
Okay.
I just, oh, it might be on the facilities website. I can't say for sure, but that could be a piece of information that's on the facility website.
Okay, so that's the last of our questions. I had a couple thoughts about trying to resolve, excuse me, trying to resolve issues in the facility, and then we'll go for last thoughts from you folks as well. But a few years ago, I had this great epiphany when I was running that the main job of a lawyer is to try and persuade people to do something they're reluctant to do. And I thought this was a brilliant idea. I came back and I was telling my interns this, and one of the other lawyers was walking by and she said, "That's what I do with my 2-year-old." And it occurred to me that that's actually what we do in most of our life, is we're trying to persuade someone to do something they're reluctant to do. This is really common when we're in a facility or when we're working with the field office. And I think the importance of thinking of it that way is that when we think we're going to try and persuade them, it means there's going to be a conversation. We can't make them do anything. Like, for instance, with the standards, we can't go to court over the standards because they're not regulations. So we need to persuade them to maybe to just follow the wording of the standard. But so entering it as a conversation, and then the idea of that they're reluctant to do it. They have logical reasons why they're reluctant to do it, and we have logical reasons why we want them to do what we want. But the good thing is we don't have to convince them that they're wrong. We just have to convince them that there's a solution that works for both of us. And so in the course of this persuasive conversation, we're trying to find that thing that works for both of us. And, you know, I find that there are people who cannot be persuaded, but in general, if you go into it with that attitude, the prospect of being successful is much greater. So those are just my last thoughts on that.
Sorry, my screen went black.
Yeah, it's back up.
It is, okay.
Yeah,
Can you, I guess it doesn't really matter. We're not really referencing anything on the screen. I can, there we go.
Yeah, I can see it.
Okay. I thank you very much for that, Bob. I do find that when we get a conversation going on some of these issues, people are generally willing to engage and by and large want to do the right thing. So when we see something that it's something that is not in line with the detention standards that we can point out, and like I mentioned earlier, sometimes the field office doesn't really even know something at the facility is going on, or so really the stakeholders who bring these issues to our attention are our lifeline to know that, and the drill calls are very informative for that purpose as well, so that we know what we do is elevated based on a call from a detainee or a stakeholder, and that's how things usually happen. So I just want to encourage everyone to just let us know. I can't promise we can always find the solution you want, but we will look into it and we will start a conversation at least.
We just had another question come in for, let's see. It says, I lead a group of non-lawyers, non-religious folks who visit at a Minnesota County jail for 3 years so far, and visited at another Minnesota County jail for 6.5 years that ended housing of ICE detainees in December 2017. We're seeking to gain access for our group visit program at a couple of other Minnesota County jails and are receiving pushback from the sheriff, program coordinator, and jail administrator. what recommendations would you have for gaining access so we can offer our program of presence and solidarity?
So as it happens, I'm going to Minnesota in 2 weeks, I think, on the 15th and 16th. I'm meeting with stakeholders. I'm meeting with the law school and the group that provides the legal group presentations at Sherburne County and a few of the other facilities. So what I would say is this is the perfect time to send me whatever issues you're talking about directly to me or my email, and I can add them to the larger issues I'm looking into while I'm there. I will be also visiting Sherburne County and I believe Carver County while I'm there. But generally, I know there are no dedicated facilities in Minnesota. When it's a facility that houses both ICE detainees and regular inmates, sometimes it's more of a challenge because we don't have the kind of scale at those facilities, but they should be following all the same detention standards as dedicated facilities.
I missed the last few words of that. It was they offer a program of presence, solidarity, and emotional support. I just wanted to make sure I completely read the question.
So it's I'm sorry, Bob. Is it a religious group? I missed that.
They said not. It was not a group of non-lawyers, non-religious folks.
Non-lawyers, non-religious. So just kind of people, general population, just kind of like a visitation and detention, something along those lines.
Correct.
I think you can send it to me and I can reach out or I can ask about it. But that generally that kind of access shouldn't be a problem.
Okay. So I have nothing else. Do you at this point?
I don't have anything else. I just wanted to thank everybody for dialing in today and for all these excellent questions, and encourage you to keep in touch and let us know let us know what's going on out there.
Okay. And I want to just give one last thanks to Paula Shapiro of the ABA section of Civil Rights and Social Justice, who helped make all of this possible. We couldn't have done it without her.
Yes, thanks. Thank you. And I want to say thank you to you too, Bob, you and Paula for hosting this event. Thank you.
It's my pleasure. I think I make a nuisance of myself sometimes, but I appreciate your folks' work as well. So that's what we'll sign.